Good morning. Welcome to the webinar. This is Roger Royce. I'm the founder of the Royce Law Firm, a business, corporate, and tax law firm with offices in Northern and Southern California. I want to welcome you to our weekly webinar series. The topic of discussion today is employment issues during the summertime. As you know, summertime is coming, and for a lot of companies, that means understanding employment law issues affecting employees hired and employed during the summer months. Trainees, interns, part-time employees. Today, our webinar speaker is Lisa Chapman of the Royce Law Firm. She's going to give an informative and an essential webinar for business owners, human resource managers, and supervisors. We're going to cover how to handle unpaid internships, requests for leaves of absence, requests for flexible schedules, and other wage and hour issues. Now, you should note that on your screen there is a dialog box for you to type in questions. And if you have questions during the webinar, go ahead and type those in, and at the conclusion of Lisa's presentation, we'll go ahead and take a few of those questions, time allowing. We plan on concluding at noon Pacific Standard Time, right on the dot, like we always do. A few words about Lisa and the Royce Law Firm. Lisa is an employment and litigation attorney here at the Royce Law Firm, whose practice includes both counseling and representing and defending employers and employees. The Royce Law Firm provides transactional tax, business, and corporate law services, including employment and litigation, to closely held emerging growth and middle market companies, as well as private equity, angel, and venture funds. Our clients include companies in the technology, alternative energy, mobile, internet, as well as more traditional businesses such as food services, real estate, and manufacturing. Many of our clients are multinationals with product development, manufacturing, and distribution all around the world. So with that, Lisa, I'm going to turn it over to you.
Thank you, Roger. Good morning, everyone. The issue with that summertime presents as an employer or for a company stems from the fact that a lot of things actually change in the work environment over the summer months. Typically, rules become more relaxed as people come and go, take more vacations, and sort of typically tend to assert a little bit more freedom in their work environment, both on the company side and on the employee side, employees asking for such freedom. And with that, you know, we've got some problems that companies have to deal with because they've got a changed work environment and often operating on less than a full staff. So I'm going to talk about some of those issues that as a company, you will probably encounter and just need to be mindful of. Another issue which I'm going to talk about is what to do with your interns. Like most companies, I'm assuming that you've already been flooded with requests for internships, and perhaps you've even agreed to accept some folks as interns. However, before you do that, you need to understand the rules of the road, both in terms of compliance with wage and hour laws and also other related issues. And let me speak about the related issue piece first, and that is typically interns are students. Typically, these are folks that have not been trained about all the conventional wisdoms that relate to how one should conduct oneself in the workplace. They're inexperienced, typically immature, they just don't know how to behave. When you bring folks like that into your workplace, people in charge of monitoring their conduct need to watch carefully because interns can really change the dynamic of your workforce and can expose you to risks that you thought you didn't have to worry about anymore. These are people that have not been to sexual harassment trainings, are not particularly well-versed in wage and hour laws. They haven't been working with HR. They may have the company handbook, but they certainly haven't seen one before. So you have to keep that in mind as you introduce these people into your workforce, and just be very, very careful because there is a lot of risk, a lot of potential for risk. The first issue I'm going to focus on, there you go, is the risk identified as a failure to pay wages in compliance with wage and hour laws. This is the most important issue that you need to think about when you hire an intern. And the reason why is most companies or individuals in our society seem to think that they don't have to pay interns. Internships are considered to be places where typically students go and work for free for the summer. Now, that may be true. However, it's only true that a company is not obligated to pay an intern when the company complies with some pretty serious rules and regulations about how you treat that intern. So I am going to speak with you initially about how you can ensure that your company is in compliance with wage and hour laws, and therefore on that basis not be obligated to pay your intern wages. As a general matter, as you probably all know, if a worker is considered an employee under California law or federal law, then wage and hour laws apply. As you also probably know, among other things, wage and hour laws obligate employers to pay employees' wages at a certain rate and frequency. These rates are determined by state minimum wage laws. So what we will be talking about here is the general question of, do I have to pay my intern minimum wage laws? Now, keep in mind that in California, the minimum wage rate is $8 an hour. However, understand that in some local jurisdictions, higher rates apply, and when there's a higher rate, that rate governs. So when in doubt, go with the higher rate. For instance, in the Bay Area, San Francisco is a good example. The minimum wage rate in San Francisco is $10.55 an hour. Therefore, if you are a company whose employees are working out of a San Francisco office, you need to pay them $10.55 an hour. In California, the law that governs wage and hour laws is the Fair Labor Standards Act, or FISLA, FLSA. And essentially what this statute does is it defines what is an employee. Generally speaking, this law provides that someone is an employee if this person is allowed to, quote, suffer or is permitted to work. So if you meet that definition, and we'll talk about that, then you have to pay wages. Basically, if your worker does not meet that definition, by way of example, is determined to be an independent contractor, you do not have to pay that worker. So in the context of an intern, this statute provides for exemptions from state and local, again, the San Francisco minimum wage laws, under very, very limited circumstances. By this I mean if you meet these criteria, you will not have to pay your interns wages. Now, keep in mind that nothing I will say should imply or infer that companies are immune to all other laws governing the employer-employee relationship. They are obligated to treat their interns as employees in every other manner, so every manner other than in terms of paying wages. So you have to keep in mind that your company has to comply with all other laws concerning employees, such as not treating them in a discriminatory manner, not allowing, preventing sexual harassment, complying with federal immigration laws, etc. In short, simply because you are not obligated to pay an intern wages, that does not mean that you have a pass. You have to comply with all other employment-related laws. I'm speaking today solely about the for-profit companies, not nonprofit companies. And that's important because there are a lot of distinctions, but for the purposes of this, please understand that I'm focusing only on the for-profit arena. So the central test for unpaid interns includes a list of criteria. The first one is that the internship, even though it includes actual operation of the facilities of the employer, is similar to training which would be given in an educational environment. This is translated as a practical matter by the courts to mean that some sort of training must be provided. You cannot simply have an individual come in, call him or her an intern, and have them work for you. You have to actually train them in some element of their job. There needs to be a very strong educational component. I'm going to give you an example that I recently found out about, and that involves my child who just accepted an internship. And as I questioned the future employer, I was told that she is going to attend a class every single week. It has been assigned a supervisor, and there is a very explicit training program component to her position. If you're going to hire an intern, you need to put pen to paper and have an actual written summary of how you're going to train. And this is important because you want to make sure that the intern knows what he or she is getting out of it. This is not just an opportunity for an intern to pad a resume. The intern needs to do more than that. The purpose of this is to protect the intern from being taken advantage of by a company, but also to make sure that this is a meaningful experience that actually helps the intern in his or her future employment. The second criteria is the internship experience is to be for the benefit of the intern. You have to establish through this training program I just spoke about that the intern is getting something other than a mere resume notation. So for instance, if you're a law firm, you want to have training classes, you want to have a schedule that shows that if you're, for instance, a litigation firm, you're taking the intern to court, you're letting the intern draft briefs, you're critiquing those briefs. If it's a corporate law firm, that you're helping them draft minutes, etc. If it's a company, a software company, you've got someone assigned to work with them on software projects, someone's monitoring their work. There are regular meetings with supervisors to discuss the progress of this student. One other element or manner in which you can satisfy this criteria is to have some kind of a article or some kind of a some sort of product that the student or intern can create, which can help show that the student did something other than just go file papers or whatever sort of administrative work that a company may want an intern to do. The third requirement, or test rather, is that the intern does not displace regular employees but works under close supervision of existing staff. This is really very important. The intern needs to be an add-on worker, not someone that is used to replace someone on, say, for instance, maternity leave or someone taking a vacation. Again, as I said earlier, there needs to be close supervision of what the intern is doing. I highly recommend that you require the intern to keep some sort of a log about what he or she does so that you've got some evidence in the future that there has been compliance with these requirements. The next requirement is that the employer that provides the training derives no immediate advantage from the activities of the intern, and on occasion its operations may actually be impeded. I'll have to say that it's virtually impossible to satisfy this, and my understanding is the courts appreciate that. The reason why is adding a body at your office is going to provide some advantage to you in some manner. I think the point of this, though, is that the intern should not just be plugged in as someone who's doing filing or just answering phones. There needs to be something else going on for the intern. The fifth element is that the intern is not necessarily entitled to a job at the conclusion of the internship. This is really important. The intern must not be promised that if he or she does well, there's a job waiting. This can't be a situation where a worker is on probation working for free to let the company get a look at how he or she is going to perform. To the extent someone is hired subsequently, you need to be very careful that you have carefully documented what this intern did, because this is a very important element. This is not to say that companies should be discouraged from hiring their interns, but that you can document that there was no promise made and that the work done by the intern was not the exact same work that the intern will do if he or she is hired subsequently. And the last test or requirement is that the employer and the intern understand that the intern is not entitled to wages for the time spent in the internship. This is really an important factor, and you should have this in writing. The key here is if you don't do this, then you could draw a lawsuit, a wage and hour lawsuit. And it's tough for an intern to argue around the fact that he or she signed a document that acknowledged that no wages were going to be due. So this is really an important protective measure for you. Related to that point, the internship should be of a fixed duration. You need to establish the start and stop date at the very beginning. And if the intern does subsequently get a job, you need to have some sort of a break so that you can prove that this is not a trial period. The internship was not a trial period for future employment. So in conclusion, some of the common issues and concerns that you need to consider are, number one, the internship needs to be similar to an education environment, and the primary beneficiary of the activity needs to be the intern. Number two, concern yourself with displacement of existing workers and supervision issues. The intern needs to be supervised. This is a mandatory requirement. And finally, job entitlement. The internship needs to be of a fixed duration, and it should not be treated as a trial period for future employment. My final thought on this is, when in doubt, do pay your intern. It's not a good risk to draw a wage and hour lawsuit on this issue because courts typically do not look with favor on companies that appear to have taken advantage of students. So I would say to you, if you cannot actively train your interns and follow these rules and the criteria, then it's in your best interest to simply pay them a minimum wage. The next issue I'm going to speak with you about is the increased risk of sexual harassment and sexual harassment claims during the summer. Now, as we all know, during the summer months, as I indicated, the environment of the work environment can change quite intensely. Oftentimes, companies will have a summer party somewhere. It's typically company-sponsored, and typically also there just is a lot more of a relaxed attitude in the office and outside of the office. So you have to be, companies and their HR staff need to be careful and really watch carefully or watch closely how their office environment has changed during the summer, if at all. It's quite common that sexual harassment problems arise out of company-related parties and some of the behaviors that are attendant to that. I'm going to start with talking a little bit about some basic sexual harassment law so that you just get a quick update. You may all know this, but it's good to have knowledge of this. So as you probably know, there are two types of sexual harassment. The first is quid pro quo, or economic quid pro quo, Latin of course, and this is where an employee subjugation to sexual conduct is linked to the grant or denial of a job benefit, such as getting or retaining a job or receiving a favorable job review or promotion. In other words, if you comply with my request for sexual conduct, I will give you a job. That is quid pro quo. That is not something you ever want any employee being involved with. It's highly risky conduct. The second type is more common. It's a hostile work environment. You've probably heard that term a lot. People seem to use it even outside of the context of sexual harassment these days. And this is where the sexual conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creates an intimidating, hostile, or offensive work environment. Liability, the issue of who is liable for sexual harassment comes up oftentimes because a lot of employees don't understand that they might be personally liable. Supervisors are personally liable for sexual harassment of a coworker. The company is also liable for any sexual harassment. So in the case of a supervisor, they need to be particularly aware that they are putting themselves personally at risk. And this means they may very well have to pay for their own defense in a lawsuit, and they may have to pay damages if they are found to be liable. Proving sexual harassment. This really speaks to the issue of what is the legal risk here. So do understand that the bar is considerable. It's quite high to reach a finding of sexual harassment. On the flip side of that, the risk of losing a lawsuit and the cost of defending a lawsuit is also very high. So typically, most companies don't want to turn over this type of claim to a jury because they don't want to trust that a jury will agree with their point of view. It's just not a good gamble. So my advice to companies is focus as much attention as you possibly can on avoiding sexual harassment at the front end. Don't test the waters in litigation. Don't spend the money on litigation. In the recent cases I've handled, the legal fees exceeded $100,000, and in some cases substantially more than that. And though the case is settled on the eve of trial, the companies had to spend a lot of money on either resolving the matter amicably or enduring the litigation costs. And that's the dollar cost is one minor piece of this, because more profoundly, as my clients found, the experience of going through sexual harassment litigation is really quite traumatizing to the entire company, not to mention the individual accused of the wrongful conduct. So back to the issue of proving sexual harassment, it's good for you to understand that in hostile work environment cases, courts consider the level or severity of the conduct. So how bad was it? Did someone touch someone, or did someone just look at someone in a sort of leery manner? And the frequency of the conduct, so how often was it, and whether the conduct was physically threatening or humiliating. There's a continuum, and there's no black and white line. It's a profound gray area, and this is all brought up in the context of what one person says versus what another person says. It's a he said, she said situation. Typically, these cases are driven by social media. I haven't seen a case like this in years that wasn't defined or bracketed in terms of dollar amounts for settlement by emails, chats, IMs, text, and video. iPhone or smartphone cameras are now the most prevalent form of evidence that is used in this type of case, both in defense and in offense. But it's pretty much a maxim or standard belief among those practitioners that do what I do that there is going to be a picture of pretty much everyone in a compromising situation. So keep that in mind. So let's talk about the implications for the summer. First of all, company-sponsored events. While you may think if you hold a picnic on a Saturday at a park, you are not potentially liable for sexual harassment, do think otherwise. If it's a company-sponsored event, there is a strong likelihood that the company could be deemed liable for acts of sexual harassment that occur at that event. This is not to say that all events held outside of the office on a weekend are going to be found to be company-sponsored events for which the company will be liable for acts of sexual harassment. But it's a very strong likelihood that that will occur. And this is particularly true in situations where employees are encouraged to attend. So if you're having a picnic and you send a lot of emails out encouraging people to attend, and supervisors strongly encourage people to attend, err on the side of caution and assume that for purposes of sexual harassment law, it will be determined a company-sponsored event. This means that the company needs to take a lot of steps to ensure that sexual harassment does not occur. It is better, much more advisable, to just assume that you've got a risk and watch out for it. I recommend that if you have a company-sponsored party, to the extent you can, you avoid serving alcohol. Alcohol, as everyone knows, is going to change what happens at an event. People's guards get let down, and they say and do things that they wouldn't necessarily say if they were drinking a lemonade, for instance. So good excuse to give the company party at a public park where alcohol is prohibited. If you introduce alcohol, you need to have a program to monitor what's going on, designate someone or some people to really watch what's happening. You should also talk to your managers and alert them to the fact that they need to watch out for management and watch how employees are behaving. Of course, this puts them in a bit of a position of responsibility, but perhaps that's just one of the things that I think needs to go along with being a manager. So again, if you're going to serve alcohol, you need to behave differently and step up your monitoring. By the same token, outside of the sexual harassment context, do know that you need to make sure that if your employees leave intoxicated, that the company could potentially be liable because it could have been deemed to be a work event, and therefore you need to take the keys away from anyone who appears to not be able to drive safely. Now, one of the other things to think about for purposes of summer and sexual harassment risk is the fact that it's just a more relaxed environment in a lot of firms. There's a lot more casual social events, people going out by themselves or as groups of coworkers to restaurants, etc. Typically, you would think, I would imagine, that such events are not considered company events. However, I have worked on cases where those sojourns to local bars were actually found to be company-sponsored events. Employees have argued that they felt intimidated into going, that if they didn't go, they wouldn't get a promotion. They felt that it was necessary to stay in the loop and to work with their managers and supervisors. When you have managers and supervisors there, it creates a greater impression that it's a work-related event. My experience, if you've got managers or people in supervisory positions going out with other folks, you need to make sure, or that folks that aren't managers and supervisors, you need to make sure that they fully understand that they could be exposing both themselves and the company if they are sexually harassing anyone. And to the extent they want to be involved with their coworkers, they need to make sure that they're not harassing the coworkers. Actually, I typically tend to tell my clients that it's best if you're a manager or supervisor to avoid any kind of personal relationship with people that report to you because it would be seen by most courts as a potential harassment relationship. Remember that relationships do change. What starts out as a voluntary, amicable relationship, oftentimes when there's a breakup, it's perceived to be harassing and the basis of a sexual harassment lawsuit by one of the two parties. Attire is an issue in the summer. Lots of people dress for warm weather, and this means wearing less cover-up. So that is going to dial up the dialogue and could lead to comments. And again, managers need to carefully monitor the situation. If employees are dressing too suggestively, they need to say something or say something to HR, and HR needs to deal with the situation. It's not in the best interest of the company for people to dress too suggestively because it can lead to more sexual harassment related comments. So my final recommendation on this issue is that managers need to be properly and fully trained. They need to be told before the summer that they need to watch out and be on the lookout for behavior, conducts, or words that could be found to be sexually harassing or constitute acts of sexual harassment. They need to have protocols where they report the behavior, and HR then needs to deal with it. Protocols need to be followed so that employees are not treated in a sexually harassing manner, and or that the company is being protected against false, trumped-up charges of sexual harassment. The final issue, which I believe companies need to be aware of during the summer is the increased risk of wage and hour violations. And this arises out of the fact that employees typically take vacations, and other coworkers are then forced to pick up the slack by working longer hours, which results in potential wage and hour violations and discrimination claims. So the first issue is wage and hour issues. Just a reminder, you probably know most of this, just a couple of high-level points. Generally, when an employee is subject to the employer's control, all of the time that the employee is, quote, again that word, permitted, unquote, to work must be paid for by wages. And this starts when the employee shows up to work, and it ends when the employee stops working. Not when the employee leaves the office, but when the employee stops working. If the employee goes home and continues to work on his or her personal computer, then that is considered working, and those are hours that the employee needs to be paid for. Now, again, reminder, as many of you may know, if you have your employee drive to an event or a work site outside of the office, you have to pay the employee that time spent. So the workday starts when the employee leaves his or her home to drive to the work site. And this is a very common mistake that a lot of companies make, by the way. And I advise our clients to have their workers show up at the office and then commence the drive to a work site, if at all possible. I realize it's inconvenient for some people, but unless you're going to carefully track how much time the employee spends driving to the office, to the work site, you're going to be exposed to a wage and hour claim for not paying them for that driving time. So another issue, again, just high level that you probably all know about, and that is some employees are exempt from overtime laws. And this is determined by wage orders published by the state of California. And there are a series of tests that courts and the the Labor Commissioner's Office will look to determine whether or not an individual is actually exempt from overtime laws. Typically, it's the test involves a review or evaluation of the duties the worker had on his or her job and the salary or the amount of wages the employee earned. The critical factor here is that employees who are treated as exempt and therefore not paid overtime for overtime work or given paid meal and rest breaks, or unpaid breaks rather, that the risk is if you make an improper or bad decision, you're going to have to go back and pay these folks who should have been given overtime all wages that they might have been due, that they worked longer than 8 hours, up to 3 years going back. So you've got a 3-year limitations period, and if the court finds that you didn't pay overtime and you treated someone as non-exempt when they were exempt, you're going to have to go back 3 years and make that employee whole. Just a little bit on the overtime compensation rate in terms of when it's required. Any hours in excess of 8 hours in one day, employees get 1.5 times their wages. Any work in excess of 40 hours in 1 week, again, 1.5 times. The first 8 hours worked on the 7th consecutive day in a work week, again, 1.5 times their wages. And any work in excess of 12 hours in one day, and any hours of work in excess of 8 hours on the 7th consecutive day, the employee gets 2 times their hourly wage. Makeup exception. This is something that a lot of companies are not familiar with, and it's a great tool for companies. If it's done properly, it helps you deal with situations where employees want to take time off, but you, the company, don't want to pay them overtime. If an employer improves an employee's written request to make up work time that the employee lost as a result of a personal obligation, say a doctor's appointment or taking a kid to school, the hours of that make-up work time, if performed in the same work week in which the work was lost are not counted towards computing the total number of hours worked for purposes of overtime requirements. So you can, there's an exception I will speak about in a moment, but essentially employees can allow their workers to make up time as long as they have a process whereby the employee makes a written request and you carefully monitor the hours spent. Now the exception is for hours in excess of 11 hours of work in one day or 40 hours in 1 week. So again, this is something that will be more common in the summer because, for instance, workers with families may have more driving obligations for their children when the children are out of school, etc. So keep this in mind, but make sure you do this properly. Now, on the issue of compensatory time off in lieu of overtime pay, under the Labor Code, certain employees can elect to receive compensatory time off in lieu of overtime compensation at a rate of no less than 1.5 times the regular rate of pay for each hour of overtime work. This is very, very limited. It's allowed on a case-by-case basis. I'm not going to go into any more detail about this. I just want you all to be aware of this concept. And last, there is the issue of meal and rest breaks. As you probably know, employees are entitled to 10 minutes for every 4 hours, which needs, pursuant to a recent state Supreme Court case, to be taken in the middle of each 4-hour period, if practical. And employees must be given a meal break or an opportunity to have a meal when they work more than 5 hours in a day. They need to be given 30 minutes. Employees can waive this, and there are additional requirements for workers that work longer hours. The final issue I want to talk about in the context of the wage and hour is discrimination. And this is a big issue for the summer. So certain employees are going to want to take vacations, have more flexible schedules, etc. Whatever you decide to do in terms of how you dispense, etc., or have some people work longer overtime because they're covering for other employers, make sure you treat everyone equally. Make sure that that there is a set formula and protocol that gives everyone an equal right to benefit from your decision making. Be careful that you don't impact one group of employees or class of employees, say by a gender or ethnic background, etc., any differently than another. Because this is the type of situation where you can inadvertently discriminate against your employees just simply because you didn't look at it from that point of view. So just be mindful of that as you walk down this path in the summer. So that concludes my, my prepared remarks, and to the extent there's any questions, we can address those.
Thank you, Lisa. I want to let the attendees know that this presentation is being recorded. It will be available for replay on our site at Royce University, as well as the Royce Law YouTube channel, and available for download in the as a podcast in the iTunes App Store. So, Lisa, one question that seems to come up a lot during the summer is everybody uses interns, and we all know that anecdotally that people, one of the reasons they use them is to be unpaid interns, and it's really a little hard to understand where that line is between what they can do as an intern being unpaid and what they actually have to be paid for. Can you elaborate a little bit on that? Because I know a lot of our attendees are going to be talking about summer interns.
Yes, Roger, that's a fantastic question. So let me approach it from more of an anecdotal point of view, and that is to say you're an office, you're a business, say you're a law firm, for instance, or you're, again, a software company. You can't bring an intern on, a student on, to just do all your filing, for instance, or do all your calendaring. They cannot simply come in and do administrative work for the entity that someone else would do in the absence of the intern doing that work. So if you're a law firm, for instance, you want your interns to be given the opportunity to do something that relates to the practice of law. So they need to observe lawyers doing work, they need to write articles, but they should not be put in a situation where they're simply filing. So they need to do something substantive that relates to the business of the company, but in a manner such that they're doing it to enhance their own growth, their own skills, and it's giving them an opportunity to grow. I do, by the way, Roger, as a practical matter, recommend companies pay their interns. It takes a lot of risk out of the equation. I can appreciate if you're a large company and you've got 20 interns, that's just not feasible. But in those situations, as I said, carefully monitoring what they do, having sessions with them weekly, lunches where you talk about substantive issues, that will go a long way towards avoiding a wage and hour lawsuit and or just doing what you need to do to comply with the law.
Okay, and I want to remind our attendees that the slides here are going to be available on SlideShare as well as Rice University if you want to get just the written materials. So another question, you had mentioned that there seems to be a heightened risk of sexual harassment claims during the summer because of maybe summer hours or company parties or things like that. And of course, we all know that those sorts of claims can be huge. They can, and I personally am aware of companies being bankrupted because of those types of claims. And it just seems like that's one that would be very hard to police against because the employer, some of its managers and other employees that management might not even know about. So really, what can a company do to protect themselves against this huge hidden risk?
The biggest recommendation I have is companies need to train their managers about what sexual harassment is. Managers should not socialize in situations where they can put themselves and the company at risk. For instance, they should not go hang out at bars after work with their coworkers that are that report to them or are at a lower status in the company. If it's simply a group of individuals that are on the same level, say, in software engineers that have all been working for perhaps 5 years or less, then there's less exposure for the company. But when you add in managers and people higher up the food chain, then you have a much greater risk. One other thing to remember also is that if, and they say, for instance, the first scenario, a group of colleagues went out to a bar and drinks after work, if one of the workers comes to work and shows up at HR the next day and complains about something that someone said or did, then the company needs to immediately get counsel on board to do an investigation or have HR do an investigation. Any whiff of any potential problem needs to be fully investigated and dealt with.
Okay. So we have some questions about the intern program. Somebody asked if a written agreement is needed with an intern, a summer intern, an unpaid intern.
Yeah. It's not required under law, but I highly recommend it for the reasons I talked about. Number one, documenting that you've informed the intern that they are not going to be paid. I think it's a great opportunity to go through the duties of the intern, establish the training aspects that are anticipated, the opportunities, going through what specifically the employee or intern rather will have to do. It's actually for your company's own best protection to put something in writing. It can help you prove your defense later if required.
There are quite a few questions about interns. Somebody asked whether school credit is required.
School credit, that's an interesting question. Typically, companies need to have some kind of affiliation with an educational institution. I would highly recommend that the company does try and give school credit, but do understand that many schools will not have that available. So give it a shot, try it, and it's a great way to essentially get over this hurdle of is this an intern or not. If you've got a school endorsing it, you're in a much better situation. But again, a lot of schools, high schools for instance, are probably not going to allow a student to get credit for what they did over the summer.
Right. So, Lisa, you talked a little bit during your presentation about during the summer, maybe not so much here in Palo Alto, but in places that have more of the 4 seasons, people will dress a little bit differently. Some places have summer hours, and that might create some problems. Is it permissible for an employer to place some restrictions on that, and how far can they go?
Yes, employers can have a dress code. Yes, and employers should all have a dress code. Every employer in this country should have a dress code. It's really a good thing. It allows you to control your work environment. It allows you, first of all, to have an environment that is professional so that your customers and clients are not exposed to things that they don't want to be exposed to. But you set limits on people. It's perfectly acceptable to do it. However, can you tell an employee not to wear a hijab? No, you should not do that. That might be perceived as discrimination. So any type of attire that someone may want to wear for religion, unless it's highly exposes a lot of that person's body, for instance, that type of attire should be allowed, and you cannot enforce rules that prohibit or discriminate expressions of religious freedom.
So we got a question here from somebody from an unfunded startup company who views the intern as maybe a way around some of the wage and hour problems that they might otherwise have. And I don't know what it is about summer, but I certainly see a lot of companies get started in the summertime. And with every startup, of course, they want to give equity and options. Does that solve this problem that we were talking about if we give the interns some equity compensation, just give them a bunch of options?
No. You still have to comply with minimum wage laws. However, if you set up a training program and you do what I said you should do, which is sit down with that person once a week, twice a week, have someone working with him or her, make it educational, you're fine. But it is not the antidote to not paying your employees. It just isn't. You can have an unpaid intern. You just have to comply with these rules.
And do these rules apply independently in the immigration laws? For example, there might be an immigration rule. Somebody might be here on a certain visa status that doesn't allow them to be paid. Does that make it okay as a state law matter?
You know, that's a really fantastic question. And I don't have the answer to it. An immigration lawyer would have to weigh in. I know there are certain immigration statuses that provide that someone cannot get paid. What I would say is go ahead and follow these recommendations about having a training program and satisfy the requirements of being a true unpaid intern for purposes of compliance with wage and hour laws, and you should be in good shape.
Okay. All right. So, Lisa, is there anything that you'd like to add as we come to the close of the hour here?
I would just simply add that keep your eyes and ears open, watch what's going on in your workplace during the summer, and be more vigilant. Sort of like how we all employment lawyers always tell companies, be careful around holiday party time. That's when stuff happens. Again, just be aware of what's going on, and that should help you avoid some of the difficult experiences which you could encounter if you have to deal with litigation.
So, Lisa, if somebody has additional questions for you, would like to contact you or talk further, how do they get a hold of you?
You can reach me by my email, and that is lchapman, C-H-A-P-M-A-N, at rroyslaw.com.
Okay, and I want to remind our audience again that this webinar is part of a series. Our next webinar will be on May 30th. That'll be a little bit different format. We're actually going to stream live instead of using PowerPoints. And again, you can find recordings and not only recordings, but the materials and the transcripts at royceuniversity.com. The Royce Law YouTube channel, and in the iTunes App Store. Okay, and with that, we're going to conclude the webinar.